the State Bar of California. This program is being supported by funding from the State Bar. We also want to acknowledge and thank the State Bar's Council on Access and Fairness, which has been doing very valuable work on student loans and how they affect the recruitment, retention, and diversity of lawyers, including but not limited to legal aid lawyers. Our presentation today will be made by Heather Jarvis. Heather is a graduate of Duke University School of Law. She graduated owing $125,000 in student debt. And it was through the loan repayment assistance program that Duke Law offered its graduates that she was able to pay her student loans and begin her career as a public interest lawyer. She has been a public interest lawyer for more than 12 years, but since 2005, her focus has been on the problem of reducing financial barriers to public interest law. She's contributed to student debt relief policy, testifying in the House Education Committee, and currently she is participating as an advisor in the negotiated rulemaking process that the Department of Education is conducting to revise the rules on public service loan forgiveness. Heather will be presenting on the PSLF program, and in particular, the limited waiver opportunity you have between now and the end of October. She will take questions from the chat at a couple of intervals during her presentation, and then we'll have more questions from the chat at the end. So let me introduce Heather Jarvis.
Thank you so much, Jack. I appreciate it very much, and I'm happy to have this exciting information for everyone today. So with no further ado, there's some technical information for you here on your screen, similar to what Jack just let you know. I'll answer as many questions as I can today. So whatever you have on your mind, please feel free to put it in the chat and I will take a look at that periodically. We won't have time, unfortunately, to get to every good question today, but I will be happy to do that more here in the coming months so that we make sure to support you in every way that we can. So thanks again to the California Access to Justice Commission, as well as to the State Bar of California. What we're going to address today primarily is public service loan forgiveness under the Higher Education Act to begin with, as a bit of a review and a starting point. And then we'll focus our attention on the time-limited waiver that is presently in effect, known as the Public Service Loan Forgiveness Limited Waiver. I want to be sure you understand which loans are eligible for forgiveness under these more flexible rules. We'll talk about specifically how you can understand whether or not you need to consolidate some or all of your federal student loans in order to have the waiver applied to you. We'll talk about which employment qualifies and how to certify that your employment has qualified. And we'll talk a little bit about income-driven repayment plans because they are an integral part of public service loan forgiveness and will be going forward. So I know that what everyone's top concern is, understandably, is what all of this means for you and your particular circumstances. And so my goal is to give you the information you need to figure out exactly what those circumstances are and take the actions you need to take in order to benefit. And finally, we'll talk some about what the future may bring. We know there will be some rule changes. I have a sense of what some of those changes will be. There are other things that are somewhat less certain at this point. So we'll have a conversation about that as well. And we do have 75 minutes for today's presentation, so we will not be concluding until quarter after the hour. And I'm looking forward to talking to you about all of this. Much of what I refer to is housed here at the studentaid.gov website. So you'll have access to these visual aids on the Access to Justice Commission's website. But I also want you to note that a fair number of the things I refer you to are going to be screenshots from this website in particular, and they may change over time and get stale. Today is June 7th, 2022, and we have the latest information that is available today, and that will potentially change here over the coming weeks and months. So to begin with, the Higher Education Act of 1965 is what controls federal student loans, the repayment plans, the forgiveness provisions, and that legislation has been reauthorized and amended for over 50 years. One of the big legislative tools that amended the Higher Education Act was the College Cost Reduction and Access Act that took effect October 1st, 2007. I was one of many advocates who worked in teams to get this legislation done because it was apparent that the loan repayment assistance programs operated then mainly by law schools, but also by some locations and some employers were not sufficient to enable people to afford legal education and to choose lower paying jobs in the public sector, particularly the lowest paying public service jobs for law graduates, which tended to be civil legal assistance positions. And so the College Cost Reduction and Access Act created public service loan forgiveness and the first really affordable income-driven repayment plan. When I say income-driven repayment, IDR, that is meant to be an umbrella term that describes the individual plans that are available under income-driven terms. So there's income-based repayment, income contingent repayment, and many more. And we'll discuss those briefly today, and there is more information on them. But income-based repayment was the first real affordable income-driven repayment plan. And it was part of this College Cost Reduction and Access Act, which similarly created two primary paths to forgiveness of some federal student loan debt. Public service loan forgiveness, we're going to talk about today, was set up as in such a way as to require 120 qualifying payments on student loans. And that was a proxy set up by Congress to measure 10 years worth of public service work. Understandably, what many of us as student borrowers heard was, hey, I do 10 years worth of public service, I get my loans canceled. Unfortunately, it was not structured in nearly such a simple manner, but instead had much fine print and which was then encased in lots of red tape, which made it very, very difficult for people to meet the requirements. So the first possible date at which your public service could count towards loan cancellation is October 1st, 2007. So remember that date. Whatever public service you may have done before that is great, and I commend you for it. It is from that date onward that some of your public service may count towards forgiveness of your student loans. Now, at the same time that the legislation created public service loan forgiveness, it also created a forgiveness that is tied to the income-driven repayment options themselves that does not require any particular employment. So public service loan forgiveness requires public service employment and takes 120 qualifying payments in order to achieve, whereas an income-driven forgiveness is going to be tied simply to the choosing of an income-driven repayment option and enrollment in that option over a long period of time. For some of the plans, it's 20 years. For some of the older plans, it's 25 years. And if you make payments for that long and you still owe a balance, it is then canceled and forgiven. So these are two different forgiveness options, but an income-driven repayment plan is also part of earning public service loan forgiveness. It is not a sufficient condition for earning public service loan forgiveness, but it has ended up being a necessary condition. So let's break this down here a little bit more. Under the primary rules for public service loan forgiveness under the College Cost Reduction and Access Act, the rules that have been in place all this time up until October of last year, 2021, when the Biden administration announced the limited waiver. Up until October 2021, these were the rules. And you may well have heard me make a speech at your law school or another webinar about how to earn public service loan forgiveness by making 120 qualifying payments. And as I've always said, for a payment to be qualifying, it has to meet all sorts of other conditions. It has to be a payment made while enrolled in an income-driven plan. It has to be a payment made on a direct loan. It has to be a payment made while enrolled in an income-driven plan on a direct loan while working full-time for pay for a government or nonprofit employer. And it has to be all or nothing. So there is no prorated forgiveness for getting part way to 120 qualifying payments. And what has proven the most difficult for us to accomplish is to prove that we have done all these many things to the satisfaction of the loan servicing companies that are hired by the federal government to administer the federal student loan programs. But these are the primary or preliminary rules that have been in place for a long time. They are temporarily suspended and waived by this administration in order to allow a sort of a reset and fix of public service loan forgiveness. And it was necessary because people could not manage to meet all these requirements at once in the way that they were being applied by the loan servicing companies. So it wasn't enough that you make a payment under an income-driven plan. It had to be the exact amount, not a dollar short. It had to be on time, but not just on time, also not early. And not a day late, not a day early. So there were many problems jumping through the hoops, and that's why I paid some money to be able to use this slide in my visual aids, because it captures public service loan forgiveness so perfectly. Some of the other issues, though, were that even if borrowers like me and you were, keenly aware of the detailed requirements and had spent, hundreds of hours making sure that we were jumping through all these hoops, the servicing companies themselves were poor at record keeping and had took every opportunity to undercount progress toward forgiveness. And there was not sufficient oversight or accountability. And borrowers had to rely on these servicing companies to get the information that we needed. Some of us, many of us, were told, oh, you're not eligible, your loans are too old, you have the wrong kind of loans, so you can't qualify. When in fact, we should have been told that older student loans could have been made eligible by way of consolidation. This information was not clearly communicated. And people were not able to take the action that was required. Another problem we noted and have seen as an issue with loan servicing is that oftentimes if a borrower calls and says, oh, I'm having trouble with my payments or my income is not sufficient to cover these high payments, rather than directing people to income-driven repayment options, which are much better for borrowers in nearly every case, borrowers have instead been placed into forbearance periods, sometimes much longer times even than were permitted by law. So a forbearance is a temporary postponement of the obligation to pay. And so borrowers were entered into these forbearance periods when even if they made payments, they weren't getting progress towards forgiveness. People didn't hear in a timely manner about the income-driven repayment plans or the requirements to recertify their income annually. And also people were not given the information they needed about documenting their public service employment and how to do that. So there were problems in pretty much every aspect of the system. Therefore, President Biden and his Department of Education announced a public service loan forgiveness limited waiver period. This was announced in October of 2021. I think it was maybe the 9th or the 6th, I forget. And it has been in place since then and will continue through October 31st, so Halloween of this year, 2022. And what these temporary waivers do is they use the authority granted to the president in light of the national emergency. So the COVID-19 pandemic has spawned many legislative instruments that have done various different things in order to give the government flexibility to deal with the emergency and the economic fallout from the emergency, including, according to the administration, increased flexibility with regard to the federal student loan programs. But the administration is taking the position that this authority is time limited because it is tied to the pandemic. So the administration is taking the position that it can only waive certain of the requirements under PSLF during the emergency period. And they have determined that that will end, or they announced last October that that would end October 31st, 2022. And that's the, sort of why for that date. And that's important. And so what we have now during this limited waiver, instead of that super narrow interpretation of what counts as a qualifying payment towards the 120 that are required to earn forgiveness, we now have a time when our months of employment in full-time public service employment can be counted themselves in terms of giving us credit for months that we were working, rather than looking specifically at whether a payment was made, or if a payment was made, whether it was made while enrolled in a specific kind of repayment plan, or for a specific amount, or on a specific date. So there were loads of reasons why payments were undercounted, including that they were not in the right repayment plan, or that they were on the wrong loan, or that they were late or early. And all those reasons have been temporarily suspended. And so I have to ask you to, sort of take a deep breath and let go of some of the information that you may have received in these many years since October 2007. Because you may have well been told, oh, your loans aren't eligible, your repayment plan is wrong, or you only have credit for 67 payments towards forgiveness. Many of these things may have been true when you heard them, or may not have been exactly right, but in any event, are presently different than they once were. So what I want to encourage you to do is hear us today and ask your questions about what you need to do in order to make sure that you receive what you are entitled to in the system as it exists, rather than to look back, because there is much we could do about looking back, and there's much worth complaining about. But right now we are in a sort of a win position. We've gotten access to relaxed rules. We just need to take certain steps in order to have those relaxed rules applied to our own loan histories. All right, so the most important thing for you to do is document your work in public service settings, because that's how they're going to count your progress to forgiveness, is based on your employment and driven by your employment, rather than driven by your history of payment processing in particular. So the time periods that we'll be counting are the months in which you had worked in a qualifying full-time public service job, regardless of what kind of loan you had or repayment plan you were in. And that includes months that your loans may have been in a forbearance status. Student loans have a status at any moment, and that's the terminology we use to describe the posture of the loan with regard to the obligations of the borrower. So, for example, when you borrow loans, you're in school, the loans are sent into a deferment status, an in-school deferment status. And deferment is just another status that means that no payments are due. Forbearance is a deferment, or it's a status where no payments are due. But typically those months of forbearance would not count towards forgiveness for a limited period of time. Some forbearances will count towards forgiveness. And those are any period in which you had 12 consecutive months of forbearance or more, as well as periods where you show 36 or more cumulative months of forbearance, not necessarily consecutive. Also months that your loans were in a deferment status, except for that in-school deferment status, which is the main one that exists. There are some others. Months in deferment before 2013 will also be counted. And the reason for that date is simply a record-keeping one. There's more information since 2013 about what kind of deferment a loan was in that's accessible to the Department of Ed, whereas before 2013, their records are less robust. And that's why they chose that date, because they can't differentiate between different kinds of deferments before that date. And also, and this is a very big change to what you may have heard before, if you have loans that are in a repayment status, and a repayment status first starts when you leave school, so you graduate or you drop below half-time status, then you have a 6-month grace period where no payments are due, and then your loans first enter a repayment status, as we say. And you can choose a repayment plan at that point. But it's after that date that your loans first entered repayment that you can count all the months that you did full-time public service employment, even if you later consolidated the loans. And so again, you may well have been told that consolidation will reset the clock or will cancel the payments you had made before consolidation. That was true and may well be true again. But right now, and until October 31st, it is not true because it has been waived. So even if you consolidate student loans, the Department of Education will pierce the consolidation and look through it to the underlying loans and the repayment history of those loans. So the two actions that I want everyone to contemplate, because some of us will have to take both and some of us will only have to do one of the two. I want you to consider whether you need to consolidate any student loans. If you have any federal loans that are not already direct loans, and I'll show you exactly how to do this, then they will need to be consolidated or reconsolidated before October 31st. So either consolidate or don't, but determine whether you need to consolidate and consolidate. And then number two, certify all of your qualifying employment that you've had since October 1st, 2007, and do that in a particular way that I'm about to show you. All of this happens at the studentaid.gov website. This is a place where you can log in with your federal student aid username and password. And when you do, you'll be able to see who your servicing company is. And when you know who your servicing company is, it's going to be something like Great Lakes or FedLoan or Nelnet or Navient. There are many, Mohila. Know your student loan servicing company and update your contact information both at your loan servicing company's website as well as on the studentaid.gov site where you have a profile. And the reason it's important to do both is that your servicer is contracted by the federal government to service the loans, and they are the primary source of information for you regarding your loans. However, when the Department of Education is coming in like they are now and sort of overriding all the existing rules and implementing these temporary provisions, they have sometimes more information about the status of your loans than the servicer does, which is not normally the case. But it is important that you update your contact information in two different places so that you get every piece of information you need. And you'll also be able to get a good inventory of your student loans at studentaid.gov. I'm going to show you how to check what kind of loans you have at studentaid.gov. If you have any private student loans, unfortunately, private student loans are still not eligible for any relief. The federal government has not done and is not doing anything to help us with our private student loan debt at this time. But if you're not entirely sure, if you don't see all your loans on the studentaid.gov site, it's probably because they're private. And you can take a look at those by pulling your credit report at annualcreditreport.com. All right, so I'm going to give you a little brief description of what consolidation is really sort of all about, and the pros and the cons and what's the deal with it, and how to determine whether you need to consolidate in order to benefit from the limited waiver. And then we'll pause and do some questions and launch back in. So when I say consolidation, I'm talking only about a federal consolidation loan that repays other federal student loans. Up before the year 2010, there were consolidation loans, federal consolidation loans available directly from the federal government through a program known as Federal Direct, and also through other banks and private lenders through some of the older federal student loan programs. But now, and since the summer of 2010, the only consolidation loans you can get are federal direct consolidation loans. And so some people with older loans may have consolidation loans that are not already direct. And you need to consolidate any federal loans you have that are not already federal direct, including consolidation loans. So most of us probably don't have, unless you've been out of law school a really long time like me, don't have non-direct consolidation loans, but it's possible. So I'm going to let you know how to do that. And we'll take questions in just a minute. So please do feel free to keep putting them in the chat. So this is a screenshot of the studentaid.gov website after I logged in. So you see my name in the top right corner. That's where you'll see your name after you log in. And the first thing you see is a dashboard. So the dashboard has these little donut charts, I guess they're called, not pie. And you need to click on that blue text that says view details. So that's where you're going to start by clicking view details. And after you view details, you'll see a list of all the loans you have. I had 18 loans by the time I graduated. And you then click view breakdown because you want to see the breakdown of all of your loans. And after you see view breakdown, it will show every single loan you have or have ever had. And as you can see, the first two listed here have balances, but the next one listed says zero balance because it's one of the loans that I had paid off with my consolidation loan those many years ago when I did that back in what, 2002. So you'll see a long list of loans. Many of them may have zero balances if you later consolidated them. But we still haven't gone quite far enough into the detail. At this point, after we've broken down the loans, we have to click view loan details one more time before you see something referred to specifically as loan type. Now for loan type, there's lots of different things you could see. It might say subsidized, unsubsidized. It might say consolidation. It could say direct plus loan. It could say Perkins. There's many things it could say. What you're looking for is that each of your loans, when you go to the details and you drill down to the loan type, you want a loan type that has the word direct in the name of the loan. So my loan type is a FFELP consolidation. That's Federal Family Education Loan Program consolidation. It doesn't say anything about direct because it's not a direct loan. If it's a direct loan, it will say direct consolidation or direct unsubsidized, direct plus. There's many things it could say. If it says anything that does not include the word direct, it is not a direct loan. So if it's Perkins or if it's just straight up says subsidized, not direct. So you want it to have the word direct in the name of the loan. If you have any loans that are not already direct, then in order to get the rules of the limited waiver, the relaxed rules, the better rules applied to you, you must consolidate before October 31st, 2022. You must. And I want to tell you that as part of the consolidation process, you will receive a currently outdated warning that says, warning, are you sure you really want to consolidate? Because if you do, you will lose progress towards forgiveness. And that is simply not correct at this time. It is part of what is required to be disclosed as part of the consolidation application process. So it can't be removed, even though they have other language on the site saying, hey, yeah, just kidding, that's not really true right now. So don't panic if you get this far and then you're like, wait a minute, you know, am I going to hurt myself by consolidating? Consolidating, we are assured right now, will not hurt you because you will retain credit for anything you did before consolidation that is in your favor, such as making payments on loans. All right, so this is going to be my first pausing for questions. And what I'm going to do, I know everyone's questions are important. I'm going to try to pick a few that I think may have broader application to the larger group. And I apologize for probably being unable to reach every single one of them today. We will be inviting you back in September for nothing but Q&A with me, where it's just exclusively like you ask and I answer.
Heather, let me start with one.
Please.
The slide said certify when you have 120 months, but you should certify the number of months you have, even if less than 120. Is that right?
Yes, an excellent question. Absolutely true. So it is necessary to file a PSLF form, which is the form that certifies your employment. It is necessary to certify all your employment in order to get forgiveness, but it is permitted and prudent and wise to file that PSLF form about once a year. And right now, folks are going to want to file a PSLF form for each qualifying employer they have had since October 1st, 2007, unless those forms have already been filed and properly processed. So yes, you're right. It is not only after 120 payments have been made, but it is both that you have to apply using that form after 120 payments, and that you should use that form annually to document your employment in advance.
And the limited waiver application, should that also be filed if you haven't yet made 120 payments?
There is no application for the limited waiver. There is no specific form that says, hey, I'm applying for the limited waiver. But the PSLF form has several different boxes that you can check. And one of them will say, I just want to know how many payments I've made toward forgiveness. And you can check that box as part of certifying your employment for the limited waiver. Even if you've already made 120 payments, they will evaluate that regardless of whether you check the I just want to see how many payments I've made box or not. There's also a box that says, I believe I have made 120 qualifying payments and I want you to check my forgiveness. And in normal times, it matters somewhat which box you click, but now it's really sort of either whatever box you click, they're still going to review your entire loan history now and get you as close to the 120 as you're permitted to get according to the presently in effect rules. So, and Jack, if you would like, I will take a few more questions that I have selected.
Please do.
Renee had a great question right at the beginning. She had understood that if someone had made more than 120 qualifying payments after their payment history was reconsidered, that they would be reimbursed for payments made in excess of 120. But now she's hearing that that's only the case if you've already consolidated. And she's wondering which one of those is correct. And Renee, it's actually a little bit of a kind of a both and. The Department of Education has said they are not going to reimburse any money that we sent to any of the other lenders. So this is the issue with direct loans. And the reason that we must consolidate into direct loans in order to get PSLF is because direct loans are the only loans we owe directly to the federal government. So they're the only loans that they can forgive. And similarly, from their perspective, the only loans they can give refunds for are payments that have been made to them. So, well, of course, they, if they wanted to send us money, they could. But what the Department of Education is saying is that we're not refunding any payments in excess of 120 that you have made on any loan that is not already a direct loan. So if, Renee, you have these older loans like I do that are not direct loans, if I made 130 payments on those, I'm not going to get 10 payments forgiven or refunded to me, even if I consolidate and get credit and get my loans forgiven. Whereas if I consolidate and they give me credit for 100, let's say I consolidate, I have to start making payments, right? Because they haven't canceled my loans yet. So I make several payments and then they review my loan history and say, oh, you had already made 120 qualifying payments or 130 before you consolidated. They'll refund the excess payments I made after the consolidation. But let's say I had a direct loan. I've always had direct loans and I've been making payments on direct loans. And then they review my payment history and they say, oh, you've made 130 qualifying payments on these direct loans. They'll refund those 10 extra payments. So it's really not exactly tied to consolidating for every person, but they're only refunding money paid on direct loans in excess of 120. So the sooner you consolidate, the better. And then the other question I'm going to take before I go back to the material that I want to make sure I get through today. Daphne asked if there was any need or benefit to consolidating loans if you already have all direct loans, which is an excellent question. So I will say there is no need to consolidate if all your loans are already direct, because you will have the terms of the limited waiver applied to your loans automatically without any need to consolidate, as long as you do the certification of your employment by filing that PSLF form that we'll be talking about. Whether there's any benefit to consolidating loans that are already direct, for some of us there might be, and the reason for that is that the department has taken the position that they're going to give a consolidation loan credit for the maximum number of qualifying payments that are attributable to any of the underlying loans that were later consolidated. So if you have a situation, which you shouldn't have, but loads of people do because of the poor administration of the program, if you have a bunch of different direct loans and you have some that have 60 payments towards forgiveness and some that have 37 and another that has 90 or whatever, if you consolidate them, they're going to automatically give you credit for 90 payments on the consolidation loan for the largest number of any of the underlying loans. So nobody with all direct loans needs to consolidate, but some people should. So yay. All right. I'm going to proceed through some more material and then I will pause and take some more questions, and we're right on time. So fabulous. Okay, so some people need to consolidate and some people may want to consolidate in order to get the terms of the limited waiver applied as broadly as possible. The second step that everybody needs to do is to certify their public service employment. And let me just tell you why we are where we are today, because I think this helps to clear up some of the confusion. The legislation took effect October 1st, 2007. Myself and other people were immediately said to the Department of Education, we need some way of certifying our employment, because people aren't going to count on public service loan forgiveness if they can't find out if their jobs qualify or not. And the Bush administration, when it was first passed, said, no, I don't think we're going to do that. And so we waited a while until the new administration, the Obama administration. Then we went back and said, hey, you really need an employment certification process. And they said, okay, that seems like a good idea. And then things take forever to implement, and it takes forever to get a form together. And so it wasn't until much later, I think it might have even been 2012, by the time we got an employment certification process in place. And we used to call it the Employment Certification Form, or the ECF. That form is now called the Public Service Loan Forgiveness Form, because it does more than certify employment, although that's its primary purpose. And so employment certification has changed over the years. And I want to urge all of you to use this tool to populate your form, even if you've done it differently in the past. And the reason for that is that this tool will circumvent review of your employer's qualification. And that's because it's linked to a database of employers who have already been vetted by the Department of Education. And so you will have your form processed much more quickly and accurately if you use the tool to populate the form. Even though the tool is not actually an electronic form at this point. It would be nice if it was, but it really isn't. And so the way that this PSLF help tool works, it looks like this. You start with an employment history, and you have a list of past and current employers, and you can add them by clicking the little plus add employer button. And when you do that, it gives you an opportunity to search for the employer. And that's what you want to do. You don't want to skip this part, because this is what helps you get the credit you deserve. So populate this with your employer identification number. That's the federal EIN, which you can find on your W-2 in box B. It's not the same as the state ID number. So look for the federal EIN from your W-2 and put that into the PSLF help tool. And then you'll get a list of employers to choose from. And not every single one is in there. So don't panic if you don't see yours. It doesn't mean it's not qualified. It just means it's not in the database yet. But many of them are. Primarily, this comes from IRS records, although not exclusively. So choose your employer from the list. And then you have to print the form, because it is not electronic. As I mentioned, you'll have to sign it, and you'll have to get a signature from an employer. So you have to get a form for each employer that you add, because you have to get signatures from humans at each of those organizations. And be sure that both your signature and the signature of the person that's with the organization that you worked for is what they call wet, meaning not digital. And a wet signature includes one that you draw with your finger on a trackpad, or that you wrote on a piece of paper and took a photograph of, but it does not include a signature that you type into your keyboard, even if it is translated into a font. And it does not include digital signatures, as many of us have become accustomed to using on contracts and even some court filings, where you can do that kind of thing. The Department of Ed doesn't quite have that locked down yet. But the form that is populated with this tool has a giant ugly name, but it's referred to as the PSLF form these days. And it's just got your demographic information, and you click, as I said, one of these boxes, either just want to find out how many payments I've made, or I believe I qualify now. But you can just, it's really not super important which one you click at this point. The top one is is probably the best, I would say, although again, doesn't make a huge lot of difference. And let me pause and take some more questions. Jack, do you have anything that you want to shout out, or shall I take a look here?
Go right ahead.
Okay, great. So Michelle was asking about whether Perkins loans are eligible, and yes, so a Perkins loan is a federal student loan, but it's a campus-based loan. What Perkins loans are is the feds gave a pot of money to the schools that the schools would distribute to the financially needy students, and then students would pay back the schools directly, and they would use that as a sort of a revolving fund. So it is not held by the Department of Education, so it's not a direct loan. So a Perkins loan can be eligible if and only if you consolidate it, and then they will apply the terms of the limited waiver to the Perkins loan. So essentially, if you're a Perkins borrower, you need to consolidate and you need to document your public service employment, because it's your employment, not your loan history on that Perkins loan. They don't even have access to the history on that Perkins loan. It's your employment that's going to determine how many months they give you credit for. Josh asked whether FFELP consolidation loans qualify. Josh, as like in my situation, a FFELP consolidation can be credited with time towards forgiveness only after it is reconsolidated into direct. So every loan that doesn't have the word direct in the name of the loan needs to be consolidated. You can have pretty much anybody from your employer sign the form who is authorized to sign on behalf of the employer and who is willing to certify that they have access to your employment records, because they have to indicate your start date and your end date, or whether you're presently employed. So it is any of those individuals would be fine. So Natalie was wondering about what if I can't get, you know, a wet signature. So that you may not be able to get any signature at all. That is sometimes possible. There is a box to click on the application, the form, the PSLF form that says, I can't get this signed by my employer. But I think that that should be your last ditch effort. So Natalie, what I would do is populate the form on the help tool, print it, sign it with wet for yourself, scan it, which you can get an app for your phone. I use TurboScan, and it's basically a picture of the form. And then you could email it or whatever else to somebody at your employer if you can access somebody, and then they may have to print it, sign it, scan it, and resend it back to you to submit, or they can submit it directly according to the address on the form. You can also fax it, or if you're already with Fed Loan Servicing, you can upload it to Fed Loan Servicing. Because you can say like, oh, I can't get my employer's signature, but that's just going to trigger a manual, lengthy review and requests for additional documentation about, why you can't get it and how we know that you worked there. And so if you can possibly get a signature, get a signature. Yolita wonders if she can apply now, even though she's got 9 months of public service, but is planning to stay, longer. You can file the PSLF form anytime, and what that will do is serve to record the 9 months of service you've already done. Then you'll need to continue filing them over the years until you have completed the public service requirement. And that's what has not changed. You still have to do a full 10 years of public service. You have to work full-time, which is let me just tell you actually what that is, because I'm sure someone was probably asked, even if I haven't seen the question yet. Presently, the definition of full-time is that you look to the employer's standard of full-time employment. And if they require more than 30 hours a week, then you are subject to their standard. If they do not have a policy, or if they require something less than 30 hours a week, then the student loan regulations kick in and say you have to work 30 hours a week on an annual average. You don't have to work 30 hours every single week. You can take your leave, you can take your vacation, but you have to average 30 hours a week over the course of the year. After the rules are revised, and I'm going to talk to you about that a little more in a moment. After the new regulations are promulgated, I'm virtually certain, although not entirely certain, that the new rule will be just straight up 30 hours a week, no matter what your employer says or not. And you can piece that together with more than one part-time position, and that is permitted. So, okay. All right, so let me just go through a little bit more here, and then we'll do some more questions. Fabulous, right on time again. So, okay, so loan servicing companies have historically really let borrowers down. I mean, they have not, there are good people there trying to do the best they can as individual human beings, but as an entity, as an institution, loan servicing companies have do not have the incentives to spend a lot of money or a lot of time on each one of our accounts or making sure that we get all the information we need. They have legacy computer systems that are not particularly good, and they certainly don't communicate well with one another. And so it is vital that you recognize that the rules are not always applied as they should be, and we have to advocate for ourselves. And so because of our audience today, I know that you know how to do that, right? I also know that public interest lawyers rarely treat their own self-interest as seriously as they do the interests of their clients. And so I implore you to take just enough of your time and mental energy to handle your loans in such a way so that you don't pay a whole lot more than you should, and so that they don't stop you from having the happy life and financial security that you deserve. So choose your low-paying public service jobs and serve your poor clients, but also take enough time to understand what's going on with your loans and to review the records with a critical eye so that you know whether you're being treated properly or not, and you can take action in order to get the treatment that you should within the system, as you would do on behalf of a client. So keep an eye on the loan servicing companies. One thing that you can do in that regard now is to pull up your loan history, or often it's referred to as a payment history. If you have Fed loan servicing as your loan servicer, they have been assigned to do public service loan forgiveness, but they have also quit the loan servicing business and will be leaving by the end of this calendar year. So they're no longer transferring us all to Fed loan. They're starting to put people to MOHELA. But if you have Fed loan, there's something called the PSLF payment tracker. And you may see some confusing terminology there where they have something called eligible payments side by side with something called qualifying payments. Qualifying is what we want. Eligible payments are those payments that Fed loan says would count towards the 120 if you had documented that you were working full-time in public service while you made those payments. So that's one way to see if there are gaps in the employment history as has been processed by them. Now that's whether you filed the form or not, right? So you may have filed a form that hasn't been processed. And the other thing you can do to keep an eye on the servicer is to recognize that they are agents of the government, but they are not the government, and they are required to report information to the government, who is the lender. You can access that through the studentaid.gov site when you log in. One view, and it's after you go into the dashboard that I showed you, was the first thing you see after you log in. You drill down into the details, and under my aid, there's a drop down menu that says my aid under your name after you log in, and there's a link that says download my aid data. So it's a little blue hyperlink, and you click that and a text file will download. Now the text file is very difficult to read, but that is the reverse chronological history of your loans. And so if you, like me, have seen a bazillion of them, you can tell what it means. But for you, it's going to be very difficult to read. but about the only way that you know sort of what the status is of your loans. And for example, if you're trying to see how many periods of forbearance there were or how long those periods were, you can figure that out by looking at the dates. And the way it's structured is by date. It says on this date, the loan went into forbearance, and then on this date, it went into a repayment status and like. So keep an eye on that. It's like, what was it, Reagan that said, and I don't, usually not in the habit of quoting Ronald Reagan. I'm not even sure it was he that said this, but it may have been. Trust but verify, right? So right now we have no choice but to say to the Department of Ed, hey, apply the limited waiver to my loans and give me more credit than you would have given me under normal circumstances. But then here's me saying to you, but don't trust that, count, verify it yourself. Very hard to do. The way that you want to do it is count up every month that you've worked full-time in public service since October 1st, 2007, and determine what overlap there is between your public service employment and your loan repayment history, meaning 6 months after your graduation, basically, when you first started entering repayment. Like I graduated from Duke Law in 1998, May or what have you. So it was November 1998 that I started making my first payments on my loans. So from October 1st, 2007, the entire period of time since then, my loans have been in a repayment status and they're still not paid off. So if I was able to document 120 months of public service after October 1st, 2007, then the rest of it would be canceled and forgiven. So for some of you, what you want to find is the overlap between that repayment period, essentially 6 months after graduation for most of us, and your months in employment. And then if they come back after applying this limited waiver to your account with any fewer months towards cancellation, then you can argue about it, and you should. And one way to do that, I'll show you on their website here. But let me give you the summary, and then we'll talk about the new regs, and then we'll do Q&A to close us out. So look up your loan types at studentaid.gov, right? For every single loan that you have, and make sure it has the word direct in the name of the loan. If you have any loans that are not direct, initiate and submit an electronic consolidation application there at the studentaid.gov site under Manage My Loans. And then monitor the status of that consolidation application. It often takes 30 days, 60 days, sometimes longer to process. You'll receive some communication that says like, hey, are you sure you want to consolidate? Because all these bad things could happen and you could no longer have credit towards forgiveness. You will ignore that, you'll steel your spine because you know that's not true right now. And then once the consolidation goes through, well, you don't have to wait. You don't have to wait until the consolidation goes through. You can start gathering and preparing the documents for submitting your employment certifications or your PSLF form. And you're going to do that using the help tool and getting the wet signatures and filing those. And you've got to do all of that before October 31st, 2022. If your consolidation application is still pending, that's okay. If they haven't finished the review of your record, that's also okay. But you have to do both those things before then. I was asked to address the income-driven repayment plans today. I know that they are super confusing, and I will direct you to a specific resource where you can compare the pros and cons, but let me go through with some of the highlights for you. Income contingent repayment, ICR, has been available for a very long time and is almost always just more expensive and basically useless for pretty much anyone who isn't a parent borrower of Parent Plus loans. If you borrowed money as a parent, you should not combine it with the loans that you have for yourself as an individual, unless you have a very specific rationale that you're confident about. But most of us can ignore ICR. Then there's two kinds of income-based repayment, the original one for people with really old loans and one for so-called new borrowers. No one should choose income-based repayment, either of those plans, unless you don't qualify for pay as you earn. So I can tell you, if today's student loan borrowers should look first at pay as you earn. And if you are eligible to choose pay as you earn, you may want that one, or you might also give some consideration to revised pay as you earn, because that might also be good. But for most people, pay as you earn is the best, cleanest, and cheapest, easiest of the income-driven repayment plans. It's just not available for people who had balances in October of 2012. So if you are, and I think today's crowd is more of the geriatric crowd like myself, right? People who've been working a long time, have had loans for a long time. If that's the case, you may not be eligible for pay as you earn, which is the only reason you should give some consideration to the plan called income-based repayment. Then revised pay as you earn is, it has a couple downsides. You can't separate your income from your spouse, even if you file a separate tax return, like you can for some of the other plans. Also, there's no cap on how high your payments can go, like there is on some of the other plans. Normally, the payments are capped at the amount you would have paid under a standard 10-year plan. But under revised pay as you earn, if your income allows for it, your payment could be even higher than under a standard 10-year term. But revised pay as you earn also has some very nice features in terms of how the interest accumulates or does not. Revised pay as you earn is mainly good for unmarried people, or people who are married to someone who doesn't make money, or people who are married to someone else who also owes a bunch of student loan debt. So those are the reasons. And I have included this URL here, which shows you the income-driven repayment application. Towards the end, there's a bunch of pages of instructions after the form is a table that lists very clearly like the different features of each of these plans. It's still going to be difficult for you to choose between them. And I'll just say to you, that's because they are very similar to one another. And so if you struggle and to see the difference for your own circumstances between one or more plans, it's because there isn't much difference. And that's why you're having a hard time choosing, because it doesn't really matter which one you choose. Okay, so they do tend to be somewhat redundant for folk. All right, so before we do the last period of questions, I just want to say, as Jack said in the intro, I've just finished service on this for this negotiated rulemaking committee, which is how regulations are promulgated and revised by the Department of Education. We expect them to be publishing a draft version of those rules soon for a period of public comment. They're very likely to take effect in the summer of 2023, unless they are fast-tracked. But there will be a period of time after October 31st when the kind of old rules that I showed you at the beginning will be back in effect, where you have to make the right kind of payments on the right kind of loan while you're working in the right kind of job. Then the new rules will take effect, and they're meant to be somewhat easier on borrowers to make things somewhat more like the limited waiver period. But the drafts I've seen so far that have been issued by the Department of Ed don't in fact accomplish that. So that's what is stated as the goal. We'll see where we end up. But especially if you're not somebody who's already going to qualify for your forgiveness, and you're somebody who's going to keep working toward forgiveness for a while, you want to keep your ear to the ground and listen, and for additional sessions such as this that we can do in the coming years to let you know what these new rules are. There's likely to be a new income-driven repayment plan rolled out then. It may or may not be available to people who have graduate loans. They're looking for ways to kind of shut out people with graduate loans, and I don't really know. And then the last thing I will say is that there's a decent chance that we may see some across the board loan cancellation from this president and this administration. We advocates like myself are still working hard to try to put pressure on President Biden to do that, as was promised on the campaign trail. I think it's absurdly unlikely that it would amount to the $50,000 of loan cancellation that has been called for by Senators Warren and Schumer and others. I don't think the administration has ever indicated that they would do that much. They do seem to be potentially willing to cancel as much as $10,000 across the board for folks. And right now, they're apparently trying to work out some way of doing that that's tied to income, so that high earners are left out, if possible, is what they're working towards. So, latest we've heard is that there won't be any announcement until the end of the summer, although for a while we were feeling like it was going to be any minute now. Now folks are feeling like it might be later. Similar to the payment suspension that has been presently in place, that may well be extended past its current deadline, unless it's not. So, all right, guys. Well, let me just go here to chat. Jack, did you want to?
Yeah. Let me ask one question.
Please.
Is it? Are you eligible if you've worked as a contractor for a public service organization?
Typically, eligibility as a contractor does not get you there. It depends on your direct employer. So you cannot qualify as a contractor for a government or a C3 unless the agency that you work for it is a nonprofit. Say, for example, like, so I work at a nonprofit, and I do work for the Public Defender Service of the District of Columbia. I don't qualify as a public service worker by virtue of my contract with the Public Defender Service. I would qualify as a public service worker by virtue of my employment for a nonprofit organization. So if you are self-employed, as many contractors are, if you're a 1099, if you do 1099 work for the government or a nonprofit, that does not count as public service employment.
Would you like to take a few questions from the chat?
Yeah, absolutely. Let me do that. Let me just expand the size of it.
While you're looking, let me just say to everyone, by Friday, the recording of this program and the slides will be on the website. And we're going to prepare a consolidated version of questions that you've asked in the chat that we haven't gotten to, with some answers for you. So Jasmine will be sending each of you a link to that information, and you can find it on the calatj.org website.
Okay, fantastic. So Mona, even if you're doing work for a nonprofit and if they give you a 1099, you're not what they call a W-2 employee of that nonprofit. So typically, if you get a 1099, then you prepare a tax return with that 1099. You file your tax return potentially as self-employed, or you may be employed by someone. But if you are employed as a W-2 employee of the nonprofit, you won't get the 1099. And so, to be clear, what I mean to say is they're applying the rule saying you have to be a W-2 employee in order to have your status be qualified in a qualifying employer by virtue of your employment. So, okay, so I'm asked whether it's okay to make income in addition to a public service salary. Yes, it is. You can moonlight as much as you want. You can have as many jobs as you want. The way that affects public service loan forgiveness is that in normal times, public service loan forgiveness is linked to the income-driven repayment plans, and that you have to choose one of them. And so if you make money in a part-time job on the side, that will be included in the income that is determining your monthly payment amounts. It does not disqualify you from forgiveness, but it may increase the amount of the payments that you have to make. And Michelle is asking about whether marriage affects payments under the pay-as-you-earn plan, and wondering how a prenuptial agreement might influence that. So the rule is actually statutory, interestingly enough. So initially, when the legislation first passed, It was all payments were always going to be based on joint income for anyone who was married, without regard to how they filed their taxes. We were able to get what's called a technical amendment passed right after the legislation, in order to provide a way for people who are married to pay based on separate income. But the only way we could do that, because of the legislative instrument, was by saying, okay, let people file a separate tax return. So pay as you earn is an example of a payment plan where, if you are married, the income that is used to determine your payment depends on how you file your federal tax return. If you want your payments based on your separate income, you must file a separate federal tax return in order to have your payments based on your separate income. If you file a joint tax return, a payment can be calculated with that joint amount. And then that payment amount would be sufficient to cover both spouses' required payments under that plan, without regard to whether they were both enrolled in it or not. And
Heather,
yes.
Question.
Yeah.
If you certify working in an eligible job for the entire time that loans have been on pause due to COVID, does that count?
It does. So the COVID pandemic payment suspension period will count towards the 120 payments as long as you certify your employment. So if you were, God forbid, laid off, or you were working only part-time, you can't get credit for those months. You have to show full-time public service. But if you can, the whole time of the pandemic payment suspension, which started in March of 2020, through now and through at least September 1st, will count towards forgiveness. That's right. So Michael wants to know what to do if the number of qualifying payments that are shown in that download my aid data field is not correct. So, well, a couple things, Michael. So one thing is for us to try to figure out why it's not correct. So if your loans are already all direct, then it will have to do with the certifying of employment. So if you have already certified all your periods of employment and you're sure they've counted them, then we're getting to a sort of time where we're like, okay, the limited waiver has already been applied, for example, to Michael's loans, but it's been applied incorrectly. But first thing we need to do is make sure it's applied, which requires consolidation for people with loans that are not direct, and it requires processing of all of those PSLF forms for every job you've had. If that has already happened, like if you've already gotten notification that, oh, we've increased your payment count to whatever, then you can argue about it. And the way to do that is to begin by filing a complaint with the Federal Student Aid, FSA. You do that at the studentaid.gov website. At the top right, it says submit a complaint. Very small letters. It's not very prominently displayed. So you start with that, and then you escalate to the student loan ombudsman, which is also reachable through studentaid.gov. And that's how you will get evaluation of the work that was done under the limited waiver.
Heather, we've come to the end of our time. I want to thank you for a clear and very well-informed presentation. I want to just remind everyone that all registrants to this program will get a message from Jasmine Kadura telling you where to look for the materials and the recording of this program, and for at least selected questions from the chat and some answers to them. The recording and the PowerPoints will be available by Friday, and the questions and answers as soon as we can get them up. So thank you everyone for participating. And this is the end of our program.
Thank you.